Okay, welcome back, folks. This is House Corrections and Institutions Committee. It is Tuesday, April 21st. We're going to go through the draft 1.1 for the House Judiciary Committee on S-193. This is not anything that we have done. What House Judiciary has looked at is around the court process. It is around who would be sent to a forensic facility. And it will go through the court process for when one has been, competency has been restored, and what that process would look like. And that's as far as I'm going to go, because that's what I'm familiar with at this point. It does not deal at all with the pieces of our jurisdiction that we're looking at. It's only the front end, and then wherever the court's involved later on through that process is where this draft pertains. So Eric, I'm going to turn it over to you and welcome.
Thank you. Nice to see everybody. Eric Fitzpatrick with the Office of Legislative Counsel here, as the chair said, to talk with the committee about a proposed new draft of S-193, which is an act relating to establishing a forensic facility for certain criminal justice involved persons. And as the chair was explaining as well, you'll see a lot of, and yellow highlighting is what I've used to show where the changes are. Because if I remember correctly, when we had a joint hearing with this committee and with House Judiciary down in room 11. At that time, I walked through, Katie and I actually both walked through the version of the bill as passed the Senate, if I remember right. So what you're looking at now is a proposed amendment that's the result of some work in the House Judiciary Committee. And as the chair said, focusing on the front part of this process, which is not so much what's happening in the facility, but the court procedures involving how a person ends up being transferred there. How do they get there? And part of the reason for much of the language that you'll see that's different is an attempt to align the procedures with United States Supreme Court requirements around how it is that a person can be committed to a forensic type facility on the basis of being found incompetent to stand trial, for example. That's where the primary, I say that because you may recall that there's sort of two criminal procedure avenues that can get a person here. One of them is being found incompetent to stand trial, and the other one is being found not guilty by reason of insanity. There's a couple of changes to the NGRI, not guilty by reason of insanity piece in here, but the bulk of them are with that first group, the competency to stand trial. And again, an attempt to align the language and the procedures with the requirements from, at least it started in a United States Supreme Court case called Jackson v. Indiana, that said that as a general matter, yes, you can, a person can be committed after a finding of incompetence to stand trial, not being competent to stand trial, but that commitment can't be permanent, cannot last forever, at least, and this part was a little bit vague, but at least absent a finding of dangerousness. So possibly, I think there's more flexibility when you're talking about a dangerousness finding. The court wasn't entirely clear on that, but it certainly, I think the big principle you could take away from it was, as a general matter, this type of process is okay, but there have to be, and some of the cases that have come down in other states since that Jackson v. Indiana case I mentioned have gotten at this, which is that there needs to be a process for the person to have an off-ramp, okay? You can do it, but they can't just be there permanently without a way to be released if the circumstances warrant it. So that's the big picture of what the attempt to do is with this process. And that process did exist somewhat in the bill as introduced, but it's really beefed up here. That's the proposal, really be clear about how it is that person could get released depending on what they show.
So if we don't have in the proposed bill, and in our statutes, this became law, if we didn't have a real offering, then it could be deemed unconstitutional.
Yes.
Want that to be clear.
Mm-hmm. Yep. And if there wasn't an off-ramp at all, I think you'd have a real constitutional problem.
Yep.
And that would be with the state constitution or the federal?
That's an interesting point. I say that specifically with respect to the federal constitution, the due process clause of the federal constitution. But the only reason I'm really saying it is because this process, this type of commitment facility doesn't exist in Vermont. So there isn't any state constitutional law in Vermont on that point. However, there you can expect that there will be. You know, there will be. I'd be very surprised, since this would be a new thing in Vermont, a new process by which the state could deprive somebody of their liberty. You would be extremely surprised if their defense counsel didn't challenge how this worked as a possible due process violation under the state constitution. There's no case law out there because we don't have this yet right now. So in that sense, there's an unknown question, but it's another reason to try and provide as much process as you can, so that to at least improve the chances of the legislation to withstand that kind of constitutional challenge, which I'd be very surprised if it doesn't happen.
So the way the structure of the bill is right now, the person is held in a correctional facility under the custody of the Department of Corrections, under the custody of the Commissioner of Corrections. Does that even give more weight to the unconstitutionality than if it was a forensic facility that was not housed within a correctional facility and not under the Commissioner of Corrections, but under the Agency of Human Services as a whole? You see what I'm getting at?
Yeah, I do. And it's possible. It's certainly possible. Again, it's not something that I could give a definitive answer about. I think if someone were trying to make an argument about this being more of a punitive thing than a therapeutic thing, why not at least raise that point? I do think that there are some other states that also have their equivalent of the corrections department being the one that supervises these things, but there's also plenty of other states that do it more of an agency of human services type approach. So it's, but again, having no decisions from the Vermont Supreme Court at the moment as to this sort of thing, it's hard to say for sure, but it could be something that would be relevant.
So that would hope, I'm just thinking about being held in perpetuity. There needs to be a defined moment where the person is no longer held. And I can understand that with a competency restoration, but what about the not guilty by reason of insanity? I mean, the way the bill is structured, we would be incarcerating that person, and they would be deemed not guilty by the court, and we'd be incarcerating that person. And that, I would think, would be subject to a real constitutional issue.
Right. And that, as you say, is a different group of people. They were found not guilty, but they also, generally speaking, in those kind of cases, they have admitted to the conduct. They've admitted to the conduct, but they are able to successfully raise a defense that even though I committed the conduct, because of my mental state, I can't be the time of the crime, I can't be held guilty. So the Supreme Court has said, at least, that suffices for purposes of the Constitution to commit that person, because in a way, the admission to the conduct and the serious conduct, criminal conduct that they admitted to is a bit of in a sense, a stand-in for the finding of guilty if the criminal process had gone forward without a not guilty by reason of insanity procedure. So there's in that context, the court is quite specific that said that you can hold that person as long as they're both dangerous and the dangerousness is as a result of a mental illness or some kind of a mental health issue. Court did say that. It's funny, I was getting mixed up because the competency case was Jackson and the insanity case was Jones.
Jackson
and Jones. Yeah, it's two different cases.
JJ's.
Right.
Brian?
I don't know if it was just a throwaway comment, but I think when you were describing what's done in other states, you described an approach in some of them as a more agency of human services type approach.
Yep, there are some states that do it that way.
What
Florida,
does that mean?
Florida, for
What is that
example.
kind of approach?
Just means, I mean, who is the state entity with oversight and jurisdiction over people that are sent to a forensic type facility.
Okay, thanks.
Yep.
That's kind of the direction we're looking.
Well, there's examples either way. So I don't think there's a right or wrong answer at least from a drafting perspective. Easy for me to write.
So are there questions of Eric in terms of this summary? This one through about constitutionality.
So I'm going to stick with the big picture summary because as you can see, it doesn't take long to start looking into this language to sort of feel like, wow, there's a lot of weeds I could get lost in down in the details here, right? So for a moment, before we do that, let me just describe how this process works. And again, we're sticking with the competency piece to start. So we're talking about someone who's been found incompetent to stand trial. Again, not to do with anything to do with their mental state at the time of the offense. It's at the time of the trial, they either don't understand the nature of the charges against them or they can't participate in their defense. So criminal charge, there's not a conviction, not a conviction. And not only that, another difference between these two things is that the person still has a pending criminal charge against them. So they're still in custody. You know, the state still has a right to exercise custody over this person without making any change in the law, you know, because they've got a pending criminal charge. Same way people with charges against them now might be held in jail. They might be released on bail. They might be on conditions, whatever it is. That person is in that status. Again, contrast that with the not guilty by reason of insanity, where that person, criminal charge has been dismissed. They can never be charged with that crime again because they successfully asserted that defense. So in that case, and we'll see when we get to it, we had to add some language that provides that the court retains jurisdiction over that case. Because otherwise, as Judge Zone correctly mentioned down the hall, how am I going to issue an order in this case if there is no case anymore? So we're like, oh yeah, that's correct. Good point. Yes.
Yeah, I think I know the answer to this, Eric. So not guilty by reason of insanity is a plea, right?
Mhm.
But that's a specific period that you're, acutely mentally ill, right? So if you plead not guilty by reason of insanity, it doesn't mean you're necessarily going to a forensic unit unless you're convicted or unless you're exonerated by not guilty. It's post the court, right?
Yes, it would have to be a finding that you were in fact not guilty. You have to successfully raise that defense.
Right,
So,
right. So just by pleading it doesn't mean that you end up in the forensic facility,
Sure.
but you could, right, if you're also not competent to stand trial.
I think, yes, as a result of the plea, the court would have to make the finding, that it is successful. Not that, for example, someone could alert. I think, in fact, it's even in the criminal rules that if someone's going to plead that as a defense, they have to give notice to the state. Almost positive that's in the criminal rules of procedure. And conceivably the state could be like, all right, we're going to drop the charges, maybe because, it's not necessarily that every one of those offense that would be a serious offense. Could be shoplifting a pack of gum for all you know. And now that person would not in any circumstance go to the forensic facility because remember that only applies for offenses with a lifetime maximum. It's only about a dozen offenses. So shoplifting a pack of gum wouldn't be there anyway. But it could, you could still plead not guilty by reason of insanity for whatever the offense was. And the state could just say, yeah, we're not going to prosecute this case. And in that case, you're not going to end up there because there was never that final formal finding of that.
Got it.
Right. Yeah. All right. So back to this first group, the incompetent to stand trial group. So general matter, how does this work? Someone gets found incompetent to stand trial. It's one of those lifetime offenses, right? It's got to be one of those offenses. It's got to be a situation where the person is either being held without bail, or if they're not being held without bail, then there's been a finding that their release, and this is right on page 1, lines 17 to 19. If they're not being held without bail, that they suffer from a qualifying condition, and that's what we've talked about earlier. That hasn't been changed. That's any sort of mental health condition that contributed to them being found NGRI or incompetent. They're suffering from that, that upon their release would create a substantial risk of bodily injury to another person. So, and lastly, they're not currently subject to a hospitalization. So they're not already getting hospitalization treatment. As well. So those are sort of your initial criteria. Those criteria get met, person gets sent to the forensic facility. Now, what then? Well, starting at that date, the date that they're sent there, now we're over on to page 2, from that date of admission, that's line 4, we've clarified that, we start counting from the date of admission. Every 6 months, they get reevaluated for competency, right? Every 6 months.
So from date of admission.
Yep.
So they've been charged, they go to an arraignment. They meet all of the conditions in A. And then they would be now sent to a correctional facility.
The court would have to find the incompetency. So, that's number 4, I think, right? Yeah, very top of page 2.
So,
That gives you a date.
okay, so it's not from the time that the court initially sends them to the facility for an evaluation. That's not when the clock starts,
The initial competency evaluation.
right?
No, that's taken before, the court has to do that before the finding is ever made. There's a long process.
So before the 6 months kicks in
Correct.
and before the date of admission,
All that's happening. Yep.
all of that has already happened.
Mhm.
They've been deemed incompetent. And that's when one kicks in. One.
B1, exactly.
That's right.
After they've had the initial process that's all involved, like the criminal charges have been brought, the person or through their defense counsel raises the fact that, hey, or actually the court, when it comes to competency, anybody can bring that up. Prosecutor, court, defense attorney. And there has to be an evaluation, that's all done on the front end. And then after all that happens, at some point in time, if it reaches the point where the court makes a finding of, yeah, you're right, this person's not competent. Then if it's
So the forensic facility shall cause the person to be evaluated for competency to stand trial
Yep.
every 6 months from the date of admission.
Right.
So they haven't gained competency. They've just been sent there by the court.
Right.
That's when the date starts, when they're first held as a detainee.
Right. So they've just had a competency evaluation through DMH because they had to have that in order to even get to the point where they're sent here.
It's not what this,
It's not in this bill. It's totally existing law in Title 13.
but what this is stating is the forensic facilities shall cause the person to be evaluated for competency to stand trial. You're saying they've already been evaluated
Yeah,
prior to this.
that's right. And they get reevaluated every 6 months for the rest of their time there. At
Where
least.
did that first evaluation happen if it wasn't in the forensic facility?
That could be, it's an interesting question it happens through DMH oversees that. I think they contracted out, if I remember correctly. But it happens when, not in this bill, the existing process is a criminal defendant says, I'm not competent to stand trial, or the court says, doesn't look like to me like you're competent. Let's get an evaluation here. They order an evaluation. DMH does it. The person could be conceivably hospitalized if they were dangerous. They might not be. They might be out in the community. They might be in a prison. It could be anywhere at that point in time. But that's existing process that happens in the criminal process now. That's the process that precedes, for example, what you have right now. If a person is found dangerous to self or others as a result of a mental illness, remember that sort of other universe that we're trying to attempt with this bill to kind of fill in the gaps a little bit. That existing process happens now. And if the court, that all precedes the next step, where if the court finds, yes, person's incompetent, then I have to have a hearing and determine whether or not the person's dangerous to self or others. And if the answer to that question is yes, they get sent to DMH custody. So all that happens else prior to this.
Put a small line in mentioning the existing process so other people will know.
I'm just I'm not convinced that the way the language is in 2 and 3, it looks like they have not been evaluated for competency anywhere else. It looks like if they have met 1, 2, and 3, and 4 in A, they're not currently receiving treatment through an order of hospitalization. So they're sent directly from the court to the forensic unit.
After having been found incompetent
The first time.
a precondition is line 1, page 2. And that only happens after an existing process. No other way for that to happen.
Okay.
And Karen actually referenced their evaluation process on Friday. They use a outside contractor named Innova, and it's telehealth right now.
But they could have been found not competent to stand trial while they're just in an incarcerated setting, not just a hospital setting.
Yeah, they could be
As a
incarcerated.
detainee.
Sure.
So when you say from the date of admission, is it when they were first admitted as a detainee prior to them being found not competent?
No, it's only admission to the forensic facility after those 4 findings.
Okay, so prior to that, they would be in general population.
If held at all possible, right?
Okay, I got it.
Yep.
Do other people got it, or was I slow?
No, it was helpful.
It's complicated.
Yeah, I'm glad you asked.
So let's think about the big picture again, because right where we are, right? The person, all those 4 criteria happen, the person gets sent to the forensic facility, and then what? Remember, every 6 months they get reevaluated. Or it could be more often than that, because you look at B, line 5, page 2. Upon the determination by the forensic facility's clinical director that the person is likely competent to stand trial. So if sometime before that 6-month period runs, the clinical services director looks at the person and says, actually looks like this person is likely going to be competent, then they are required under this language to have the forensic facility cause the person to be reevaluated, right? So it could be every 6 months, but it could be more often than not. So what happens then? What happens either on that 6-month anniversary date or when the clinical services director says, this person looks like they might be competent? Well, that's subdivision 2. Court shall hold a hearing and prior to that hearing, the results of all evaluations have to be supplied to the parties. So everybody gets to see the evaluation. And then the court's going to have to make a finding at that hearing, right? One way or the other. Either going to have to find either that the person is competent or the person's not competent, right? That's the question at that first hearing. Either every 6 months, because remember, every 6 months they're reevaluating. And that, think about it, that's also part of the reason, the way in which we're keeping that person from being held in perpetuity. Right? Reevaluate every 6 months. And at that 6-month period, court's got to decide. Competence going to be one way. It looks like the person's competent. What's going to happen then? Makes sense. If the person's competent, we're going to let the state's attorney know and their attorney, because then they may be retried for the criminal offense. But what if they find the person's not competent? That's a different finding, right? 2 different ways. So the first one I just mentioned is line 2, page 13 page 2, lines 13 to 15. That's the one I just said. They find the person is competent, you let the people know so they can go ahead with the trial if they want to. Subdivision 4 is just some process that everyone can testify remotely. That's all that is. All right. So the other alternative that the court can find is if the person is not competent. Sorry, I think I may have misstated A and B there on page 2. Subdivision A, line 10, that's the angle where if the court finds that the person is competent, then you let the state's attorney and their attorney know so the criminal case can go forward. Subdivision B is, well, if the court finds that the person is not competent, then they say, all right, you go back to the facility and you keep getting these competency restoration services, right? So those are the 2 possibilities at that 6-month juncture, or if the person requests. Either they're competent and you go stand and let the state's attorney know so you can stand trial, or you're not competent and you go back to the facility for continued competency restoration services. But remember that choice number 2, where you go back to the facility, that's the one where you got to have more process in there to make sure that it doesn't last forever, right? So in that avenue number 2, person goes back for restoration services. That's where we're going to get to bottom of page 2 over onto page 3. Because at any time, somebody can request, either the person or the prosecutor can ask for this evaluation to include the issue of restorability. Is this person's competency ever going to be restored? And the person can ask for that at any time for any one of these evaluations to include that. State can ask for it as well. If that's the case, then over on the top of page 3, the facility has to order the person to be evaluated for restorability prior to the hearing. So if someone's asked for it, remember, they have to have an evaluation before each hearing in general. If they ask for their restorability to be evaluated, then that has to be evaluated before the hearing too. So the court's going to have some information about, hey, is this person potentially restorable or not?
Yeah, so, sorry, do you mind if I go back to page 2, line
No.
5, Eric?
Yep.
I'm just wondering, like, the facilities clinical service director, right? In the scenario sort of laid out by the Department of Corrections there, it would be the private contractor WellPath doing this. So I'm trying to think, is the intention that this would mean there's somebody on site there, or would it be, in the case of WellPath, the statewide medical director to WellPath? Would in this case be the clinical director of that facility? And it might be multiple facilities, right, if they're spread out?
I think the intent, the assumption at least, was that there would be one person in that role. I'm not sure. I don't think they had thought through like who it would be. Like, would it be? But I think even there is language later on in the portion of the bill that's in this committee's jurisdiction that requires there to be a clinical service director hired by DOC. So I think that's the idea, was it was that person. Now there may be, and there will be, while the person's there, there's descriptions of the restoration services they have to be getting, the types of services that they would be getting. So presumably there's other people involved in provision of services, but it's the director is the one who presumably based on the other information they're getting, makes that decision.
Okay, thanks.
I want to go back to line 19, page 2, starting there on page 3. This question at any time of whether or not competency can even be restored. The way this is written, do you see an exploitability here?
Or would it be? Sorry.
That can be exploited by either side, asking continuously for that evaluation?
Well, at least I think they could ask for it every 6 months. And upon a recommendation by the clinical services director that they are likely competent, although probably in that context they wouldn't
So
necessarily.
this is the restorability
Yes,
question,
yes,
right? So at the request of a party, either party,
yep,
the court may order that a competency evaluation of this substitute to include an opinion on whether the person's competency can be restored.
right.
So that to me says we're in between this, we're within that 6-month window.
Well, it's only right, but it's pursuant to that
after-
evaluation. See, line 20,
Yeah.
the evaluation conducted pursuant to subsection B, and that's every 6 months.
So do you think you can only ask that question
Yes,
every 6 months?
Yeah.
Okay.
that's the way I read it.
Okay.
Yeah, I wouldn't read it as a freestanding.
Okay.
kind of
Okay.
thing. Yeah. But if someone does make that request, then there has to be this specific evaluation for restorability. And again, you're at another fork in the road again. Because the court's going to have to make a decision at that point. All right, we've got an evaluation on restorability here. Is the person restorable or not? Right, the court's going to have to find that. And that's over on page 3. Subdivision 2, first option, the court finds that the person's competency can be restored, right? Then they order continued competency restoration treatment. Makes sense. They found, all right, competency can be restored. What if they don't? What if they find otherwise, right? Person's competency cannot be restored. That's subdivision 3. All right. In that case, they have to have a hearing, another hearing within 60 days. And this is your dangerousness hearing, right? It's at that point, the court's going to have to, because Remember, this is preconditioned on the finding of a person's competency can't be restored. So again, you're trying not to have that person there forever. So if they can't be restored, why have them there, right? Unless they're dangerous. So then they have to have a finding on dangerousness. And again, big picture, before we look at language, they find that they're not dangerous, they got to let them out. They got to release them. If they find that they are dangerous, well, they will still be subject to supervision by DOC, but there's intentionally some language in there that least restricted means. So it could be that someone, as Representative Lalonde said, there's different levels of dangerousness even, and maybe someone isn't necessarily required to be treated based on the level of dangerousness at the forensic facility. Maybe there's some other level of treatment that could work, and there's language to address that. But that's you sort of see this series of crossroads is the wrong word, forks, these series of forks that you come to. Off-ramps, exactly. And that's the idea. So that there's.
The court is in control.
Yeah, the court it is based on court findings for sure. Yeah. So again, remember, if the court finds that the person's competency can't be restored, we're still on page. They have to have that hearing within 60 days on dangerousness, and which makes sense. What do they have to do before that hearing? Line 13, page 3, forensic risk assessment. Because they're going to be assessing dangerousness. So they have to do a risk assessment because that's really risk, dangerousness. Are they and it looks at their history and present dangerousness, any tests employed, examiner's findings. There's really a public safety component in subdivision 4, line 18. The examiner's opinion as to whether the person's release would create a substantial risk of bodily injury to another person. So that's, in a sense, that's a public safety consideration. And lastly, the examiner's opinion as to whether the person is competent to stand trial.
Who's the examiner? Is that was different from the person in the forensic facility? Who would the examiner be?
That's a good question. The forensic risk assessment, it'd be a question for DOC, I think, because they're the ones who are in the supervisory role at this point. Are they contracting out? That's possible. There is language in.
So the examiner would be the same person or same entity that is doing it in the facility?
I'm not sure. I know that they are permitted to contract out any examinations that they conduct. So whether or not.
But does DOC, the court shall order that a forensic risk assessment of the person be conducted, which would include little I through the.
Yeah.
1 through 5.
Yes.
Is that person that's doing that forensic risk assessment, is that through DOC or is it someone on the outside?
I'm not sure maybe the court uses a particular entity for forensic risk assessments now. Maybe a DMH could potentially be involved now. I'm not positive. But that would be a good question for DOC, I think. Who is the party?
So if it's DOC, they're the ones who are doing the assessment. Doing the evaluation when the person's in the forensic facility.
Right.
And if the court is finding the person can't be restored competency, the court would order a forensic risk assessment of the person.
Right. So it's an independent entity.
I'm wondering, is it still connected with DOC or is it something totally different?
Right.
Different question. In the midst of all of this, does the bill address a refusal of treatment at all?
Refusal to what?
A refusal of competency treatment.
So you can't refuse, right?
Yeah. I thought it was in here somewhere. Oh, there it is. Yes, it's page 6, lines 15 and 60. Person's refusal to receive competency restoration services shall not be grounds for release or dismissal from the facility.
Does that just end the evaluation? can they still be evaluated?
I would think so. But that's kind of a clinical question too, that I'm not sure the.
I mean, my question is this, so we've got somebody in there who has been deemed incompetent. Every 6 months, they're going to be evaluated for competency.
Right.
Which is going to trigger that secondary question. But in the meantime, in between that 6 months, the person is refusing treatment for competency. Are they still going to be evaluated for competency, even though they've refused treatment?
Oh, I see what you mean. Yeah, I think the 6 months would still be a requirement regardless of what they're doing in the meantime.
But not, it doesn't trigger, it closes any opportunity for release.
Well, I don't think it necessarily closes it. It's not grounds for release. So in other
Okay,
words, in
yeah.
theory, they might still be restored even if they're refusing treatment
Or found not dangerous,
or found not dangerous.
even if
Exactly.
they've been refusing treatment.
That's right. Okay, so we have the forensic risk assessment conducted by somebody. We still want to find the answer to that question. Who actually did it?
Yeah.
But the risk assessment is done. Results, top of page 4 now, the results are supplied to the court and the parties. And then the question is whether or not the state's attorney, because this is the burden is on the state, if you're going to continue to hold somebody, it's a liberty, it's an infringement on their liberty interest. The state has to show constitutionally by clear and convincing evidence that the person is dangerous. So that's what that next language says. It's they have this qualifying condition that create a risk of bodily injury if they're released. And if the state's attorney does carry their burden, then the court orders continued, and this is line 7, continued commitment of the person. Now, here's where we get to the point of, again, because you're talking about at this point, somebody who has been found non-restorable and dangerous. So trying to provide grounds to still hold that person, the dangerousness is required because if they're not dangerous, constitutionally, they have to be released. At least they have to have an avenue for release. And this is, as you say, through these steps, this is where the avenue exists. But even with respect to that person, there's still language here that says that the person is going to be committed consistent with the person's forensic risk assessment. So in other words, remember that risk assessment looked at their dangerousness, it looked at whether what sort of threat they might pose. And then the next sentence, court shall order treatment of the person in the least restrictive setting, consistent with the person's forensic risk assessment and treatment needs. So in other words, that may or may not be the forensic facility. Might be, might not. So that if the person's still being held, then they may or may not be committed to an inpatient locked, inpatient is the wrong word. They may or may not be continue to be committed in a locked, secure facility. It might be, but not necessarily if their treatment needs don't require it.
Just kind of place this out there. So currently, there was a person who's been charged with an offense punishable by a life sentence and has been ordered held without bail. They would be held without bail. They would be held in a correctional facility as a detainee until they go to court, until they go to trial. And then the trial would determine whether they were not guilty or they were guilty, and then they'd be convicted and have a sentence. So for folks who are not competent, deemed not competent to stand trial, even though they have been charged with an offense punishable by life sentence and are held without bail, they could be released from the correctional facility to another least restrictive setting if it's been deemed that they that they've been deemed not competent to stand trial
And not dangerous.
and not dangerous.
Right.
So they would be released.
Could be.
I just want to be clear on that. So you're not treating them, some folks may say you're treating them differently, where they should be in jail because the other folks for the same crime and held without bail are being held. So why shouldn't these folks also be held? I just want to put that argument on the table. So I'm sure some folks may be thinking like that, or perceive it that way.
Mhm.
But the real issue is because the person is not competent to stand trial.
And not dangerous.
And not dangerous.
So not dangerous very much.
Yeah, if they are dangerous, the court finds that they are dangerous, they could be held. And then, so this interesting, so that's one last little wrinkle about this is on page 4. So let's say you're in that avenue that we've just described. The court found that you were not restorable and dangerous. I remember I just mentioned the least restrictive means. They have to sort of think about other ways that you might be held. You still have a continued opportunity to get reevaluated, except that it's not quite as frequently. It's every 12 months. So if you're in that group, then you still get the reevaluation. You can still, because maybe you're not dangerous anymore, or maybe your competency could be restored. All that stuff will get periodically reevaluated. But if you're in the dangerousness, if you've already been found dangerous, then it happens annually rather than every 6 months.
I think I've asked this question before. If the court deems them not dangerous and they're released, and they harm someone, is there any recourse for the harmed individual or affected individuals?
Well, you mean other than a new criminal charge based on the new conduct? I mean, there'd be that, but I don't think there's anything specific, in that sort of sequence of circumstances. If, for example, you just said, if the court deems him not dangerous, that's exactly the very next thing, starts on the bottom of page 4, goes over onto the top of page 5. If States Ferry does not demonstrate by clear and convincing evidence at the hearing that the person's dangerous as a result of their condition, then the court shall, that's line 6, page 5, order the person's release. That's when the person gets released. Again, they're under these conditions, and that the forensic facilities clinical services director is certified are appropriate. There are explicit conditions of release that they continue with their treatment, et cetera. There's also, to jump ahead for a second, well, I'll just describe it without getting into it. There's also, if the clinical services director becomes aware that the person has been released, but maybe exhibiting signs of being dangerous again, there's a procedure that they are immediately returned to the facility. But having said all that, is it still possible that someone, while they're released, could engage in some other harmful conduct? Yes. And if that's the case, the recourse would be a new criminal charge, really, and probably bring them back to the facility at that point. But admittedly, there's no way to be probably 100% sure that would never happen.
Sure.
So in this scenario, upon release with conditions.
Yep.
And in this case, it's framing it as mostly psychiatric, psychological treatment
Mm-hmm.
and any other conditions appropriate. Where I know later in the bill, it talks about the commissioner being charged with supervision of these folks.
Right.
Is that still the case? This doesn't introduce a new entity that's providing that supervision, does it?
No, it's the same. It's on page 7. It's been tweaked. It's a tiny bit, but it's really just the same. Hasn't been changed from page 7 starts on line 1.
It's still DLC.
The commissioner.
Yeah. You got it. And then the rest of that page is all about what I was just describing. If it looks like they're being dangerous again, pull them
Do
back
you
in.
know if that question has been considered by the other committee as to whether or not that's an appropriate entity for supervision?
I mean, whether it might be somebody else who would be
Like
doing the supervising.
Dale or DMH?
Right. I haven't been there for all testimony. I don't recall that topic being discussed, but it's possible that it was.
Can we flag that?
I think that's one of the issues, and the answer that we received from DOC is they would see that like the pretrial supervision.
And I think it's categorically different.
It is.
So I want to go back.
Yeah.
um, Page. Page. Where if upon the person's release would create a substantial risk.
Which line are you on? Sorry.
Bodily injury, that's on 5 and 6.
Okay, yep.
7 of page. So the court, so then the person would continue to be held by the state
Mm-hmm.
in a facility.
Great. Well, not necessarily in the facility.
Well, the court would order treatment of the person in the least restrictive setting,
Right.
consistent with the person's forensic risk assessment and treatment needs. What? It wouldn't be in the forensic facility if it's the least restrictive setting or a correctional facility, would it?
It could be, because it says consistent with the person's forensic risk assessment and treatment needs. But what if that risk assessment came back very dangerous, should not be in the community at all? Conceivably could be. That's going to depend on the results of that assessment.
Contradictory to least restrictive setting.
Sometimes the least restrictive setting is still going to be really restrictive.
Yep.
So far, the risk of hurting another person is the only condition, or not the only, is a condition to be held. What if he's not a risk, he or she is not another person, but there's still a risk to themselves?
Yep. That is not part of the forensic facilities approach. That conceivably could be, there's that existing law in which DMH could end up with custody of someone if as a result of a mental illness and they've been found incompetent to stand trial, they're dangerous to themselves. They could be in DMH custody. It wouldn't be
So
this.
it's not in here, but it is someplace else.
It is.
Also not simple, but it's not simple.
This one is particularly not simple.
Kevin's last question lost me. Thanks a lot, Kevin. So if you have this person in the forensic facility, in the carceral facility under what's being proposed here, and they then threaten self-harm, does this person get transferred out of that forensic facility into DMH's custody? Because DOC is running the forensic facility.
I think there's nothing automatic about that, but that someone could petition under the existing commitment to DMH custody on the basis of potential harm to themselves or others as a result of a mental illness for that sort of scenario.
I think you have to get into possibly that MOU between DMH and DOC, or protocols between DMH and DOC for folks who are incarcerated do get to a point in their acuity of mental health, mental illness, that they can be transferred to the state hospital for stabilization. We can do that now. We do it now.
Right.
So that may be what kicks in. For that, if someone is suicidal, self-harm, that level. Even though they may not be competent to stand trial.
All right.
Okay.
So on page 5, then we're about, remember, we just went to the piece where person has been found, they're not restorable, but they're not dangerous, so they get released. And the conditions are all this have not been changed. You see page 5, line 7 to 14. That's pretty much the same as what we're in the bill. But then you have some new language. This is all actually from the Center for Crime Victim Services. Everything from bottom of page 5 over to the top third or so of page 6. This is because the center wanted to have, as this committee is very familiar with in other settings, and wanted in this setting as well to have some victim notification procedures. So that's all that language is. That they get notified of these hearings and they can be provided with the opportunity to be present and make their views known, sort of thing that this committee has spent a lot of time dealing with.
So it's through the state's attorney and the victim's advocate that would do this?
Uh,
It's not, it's a DOC.
I think it's the court, state's attorney provides notice. Yep, and the court has to provide the victim with an opportunity to speak if they're there. And actually, even if they're not there, they have to ask if they made their views known. And that's the bulk of the changes. I'll go through, there's some other stuff we can go through probably. But you'll see nothing else changed on page 6. That's all about competency restoration services generally keep going at the facility while the person's there. Some other technical pieces over on page 7 that just kind of correlating these new subdivision cross references correctly.
So what is C5 again? It has orders, the commissioner would actively monitor compliance. This is DOC when the person's out in the.
Yes, that C5 is when they get released. Yeah. So they have to monitor compliance with those release orders. Because remember and those release orders have conditions attached.
Yeah.
So that's what they're going to have to be compliant with.
Court sets those release conditions.
That's right. And I think the clinical services director makes recommendations. Yeah. And then this is the,
Say I,
oh yeah, please.
line, page 7, line 8,
Yep.
certainly understand risk of bodily injury, but is it really limited to bodily injury?
They
What
have,
if it's mental harassment? What if it's?
they have discussed that. And they've gone back and forth on it and, you know, that could change. They're still discussing that issue, that there are people that are thinking, should it be more? On the other hand, is this more of a, when you're talking about someone, the sort of threat in the you know, if they're released that would justify basically putting someone in a locked facility against their will? Some perspectives on that is that it really should be a serious bodily injury that you're talking about, but you're right to identify that. They're talking.
Arson.
That's fine. Well, that's fine. That'd be substantial.
What was your original question? Like, it may not be somebody physically there, but they financially ruined somebody because they burnt down their store. They're not in the store, but they burnt the whole store down.
They've talked about that too. Property, should it be property injury too? Yep.
What was your original question? I didn't hear
I asked about page 7, line
Yeah.
8. It specifically calls out bodily injury as opposed to just injury to another person.
And that is a topic that people are they've been talking about it, different perspectives that could change, it might not, but anyway, it's a good flag of a topic for discussion.
In that term, substantial risk of bodily injury was put in by the Senate, correct?
Yes.
Yeah, is it, okay, skip that page 9. It's.
Hmm?
Okay, to go to page 9.
Sure.
Yeah.
Just
I didn't know if we were wrapping up the substantial changes.
Yeah, and no other substantive changes really to that page, but that's just the process of readmission. So as we were just talking about, this is where the commissioner has to monitor their compliance with those conditions. And if the commissioner, this is the language that Representative Winter was just referring to, if the commissioner is reason to believe that they're on release, they've been released, and their continued release would create the substantial risk of bodily injury, then they can return the person to the facility immediately. But there has to be a hearing right away, because again, you're detaining somebody against their will. So and they have to have a hearing, and the state's attorney has that same burden. They have to show by clear and convincing evidence that they're harmful. And if that happens, then they can readmit the person. If they don't carry the burden, then they have to let them back out. That brings us over to page 8. No changes here. This is all the involuntary medication pieces that was already reviewed at the joint hearing a couple of weeks ago. No changes there. No changes to section 2. That's the sort of related, but kind of also unrelated provision related to when the court will dismiss some of these incompetency cases that have been hanging around in misdemeanors for too long. That brings us to page 9. Representative Casey, did you have a question?
Yeah, I just wonder if there was any practical impact of changing it from acquitted to not guilty by reason of insanity there in section 3.
No, there is in the sense that the acquitted implies that there was a jury finding.
Okay.
Oh,
Or is that not necessarily always the case? Could be the court's finding.
Got it. Thanks.
You'll see the sentence on page lines 14 to 15. I referred to this earlier because remember I was mentioning that this NGRI population is in a different posture than the competency to stand trial. And there's not an ongoing court proceeding with respect to these NGRI cases because the person was found not guilty. Conviction over, done. So that's where Judge Sony was saying, well, how am I going to have authority to, because remember, similar to the other one, they're going to have conditions of release when they get out. The court, and if the commissioner, or sorry, the DOC says, hey, you got to bring that person back in because they're not complying with the conditions. Judge Sony said, well, how do I have authority to impose conditions on them? There's no case anymore. So that's why that sentence is there. Provides the committing court with the ability to retain jurisdiction when the person is committed to the forensic facility.
Did judiciary weigh in on it? Did zoning weigh in on it?
Yes, that was in front of, that's when they talked about it. Yeah. House judiciary. Senate hasn't.
No,
seen
but
this yet.
did zoning?
Yeah, I'm sorry. I thought you meant committee. Yeah, it was his suggestion. The language itself?
The committing court shall retain jurisdiction.
Yeah. He asked for the idea.
To retain.
Correct. Well, he asked the question, I guess is a better way to put it. How do I still do this? So this was something that Chair Lalonde and I talked about as a way to do that. I don't know whether he's actually seen the language yet or has said, hey, this will work or not.
Yeah, that's interesting.
But I think they're looking at it tomorrow morning or tomorrow afternoon. There's an extension of that. So in this case, remember in the competency setting, that first hearing doesn't happen for 6 months, right? Remember that? They get committed for competency in that hearing. There's a couple of reasons for that. One is they just had a competency evaluation in they just had that. That's how they got there, right? And not only that, but as I was saying, the court still has jurisdiction over these cases. There's pending criminal charge in those competency ones. NGRI, there's no pending criminal charge anymore. There's got to be a reason pretty quick as to why this person's going to be held while their liberty is going to be impinged upon by the state. So as it came out of the Senate, they had to have that initial hearing within 48 hours. That's the House Judiciary Committee said that, well, that seems a little fast since you're going to have to you're trying to get a forensic evaluation done before this hearing. Forensic risk assessment, right, lines 19 and 20. That has to be done before the hearing. But if the hearing has to happen within 48 hours, that could be tight. So they bumped that out to 60 days. So that first hearing has to be within 60 days. And before that 60 days, before the hearing, there has to be this forensic risk assessment, which is same language, same idea that you already looked at just previously in the competency context.
and again, it's not clear who does that forensic risk assessment. Is it someone within DOC? That's
Yeah, you want to ask that same question for the NGRI population too. Results of all evaluations have to be supplied to the court. That's on page 10. That's tracks identical language in the competency. And then not a lot of changes here. Again, this is all the same procedure that we talked about at the joint hearing. So this is, again, person has to be found by clear and convincing evidence. That's line 9 and 10. If they're dangerous, again, they're going to hold somebody involuntarily. The state has to be able to prove by clear and convincing evidence that they're dangerous. So that's what that is. That remains the same. And if they don't, then that's line 16. If the state's attorney does not carry their burden, the court shall enter an order releasing the person. So if they're not dangerous, they got to be released. And it's the same release procedure that you just talked about in competency. It's over on page.
I'm confused. Page 10, 13 to 17 line. The court finds the state's attorney has not established by clear and convincing that the person is suffering from a qualifying condition,
Right.
which is on the first page, those 4 items. Upon the person's release would create a substantial risk bodily injury. The court shall enter an order releasing the person.
Right.
So it doesn't matter if there is a substantial risk of bodily injury to another person. You're still gonna release the person. Because
No, that's phrased
that's
as,
how I read it.
that's not phrased that way. So it could, but it gets confusing.
Yeah.
But yes, the way it says that the state's attorney has not established by clear and convincing evidence that the person is dangerous. So they have not established that they're dangerous. Then they get released.
That's good.
But that's crucial because it's an easy, it all depends on that word not on line 13.
Right.
Not.
Yeah. Now let's look above, just so we can see the contrast. In the paragraph above, paragraph 8, line 9. If the state's attorney establishes by
Right.
clear and convincing evidence, then they get held. And a constitutional requirement there. You know,
Yeah.
has to be both dangerous and mental health condition.
Yeah.
In order to hold somebody.
And I assume, which is always dangerous, that established by clear and convincing evidence that someplace that's defined.
Yes, yeah, exactly. It's the,
Highest bar.
well, second
No,
highest,
on
on the right
beyond
track.
reasonable doubt.
There you go.
There's your highest standard.
That's the criminal. Preponderance is the lowest. And the middle one is this one, clear and convincing.
Just by preponderance, probable cause. Right?
More likely than not, or more likely, yep, a
Yeah,
probable cause.
then clear and convincing, and then beyond reasonable doubt.
Yep.
Those are all standards that have to.
They are, and those are the three.
And each of those standards must have some kind of a checklist that defines it. And that's what
No, it's not quite laid out that
Right. The courts have often said that some of them are, I think they even sometimes use the terminology incapable of precise definition. But I do have,
like perhaps to me.
yeah, but there is there's standards that or language that the court uses for each of the three.
Is that in there?
Oh, here it is.
Judicial rules.
And case law, yeah.
Not statute.
Right. Clear and convincing evidence means evidence indicating that the thing to be proved is highly probable or reasonably certain. Stronger evidence than a preponderance, less evidence than beyond a reasonable doubt. So beyond a reasonable doubt, think about it, reasonable minds can only really reach one conclusion, right? This is reasonably certain. All right, sorry, I don't know if you see the way I was able to pull that, shuffle through my papers and find I knew I had it in there somewhere. I knew it. Thank you, I appreciate that. Well, I knew I had that piece of paper in there. I printed it out thinking somebody's gonna ask this. Which is, you should, it's a reasonable question. All right, so, where? Da, 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 da.
10 or 11.
Right, yes, that's right. Okay, so yeah, this is also a difference in this draft, page 11. So again, this is a different population. This is folks, right, who have already essentially admitted to the conduct, right? This is not guilty by reason of insanity.
Does it have to be admitted or just found responsible for the conduct?
Generally speaking, the way it works is the person pleads the defense, like, even if I did that conduct, I still am not criminally responsible. So it's typically admitted. It might not necessarily be a requirement. Excuse me. So their review period is different. It gets a little longer over time. So the first one is, remember, actually, the first one has to be within 60 days. Remember that? That's the first evaluation. Then after that, next one, although they can petition 6 months after that. That's line 15 and 16, page 11. Then after that one, they have a 3-year wait period until the next one. and then it's 5 years. So they get a review that's less frequent. However, there's also a provision on page 12 that they themselves, in addition to that periodic review, automatic, they can petition once during each of those periods, and that's page 12, lines 13 through 7. So
Just once though.
during the period, yes.
So 60 days, 6 months, then the next trigger is 3 years. So you could do a year and a half.
Something you were on
6
to
months,
kind of gauge it. Yep,
and then
exactly.
maybe 2.5
right.
prior to that 5th year,
That's right.
but just once.
Yep.
Okay.
And again, just with the one other thing that is also the same as it was in the competency, top of page 12, lines 1 through 4. If the clinical services director ever thinks that the person's not dangerous anymore, they also are supposed to, they're required to have them reevaluated.
But it's commissioner of correction.
Yes. So that brings us to the bottom of page 12, which is the same process we just described for competency, which is that, a person has been released, and so they're found not dangerous, so they get released. That bring, bottom page 12 over on the top of page 13. The person who's found, if the state attorney doesn't show that they're dangerous, they get released. That's lines like, say, 6 through 14, page 13. And the same process that you just saw, bottom of page 13, commissioner shall actively monitor compliance with those orders, those release orders with conditions over on the page 14. And if they, looks like they're not complying, then they can bring them right back into the facility again. Again, they have to have a hearing right away to show that they're still dangerous. If they're not, they get released. That new language on page 14 is all the same victims language that you looked at with respect to the competency. So the same Center for Crime Victim Services wanted to have it in both places. Their opportunity, both for the NGRI kind of cases and the competency cases, for them to present their views.
Was there any testimony about her characterization of what actively monitor means? Line 20 and 13?
They were asking that question as well.
Yeah.
Yes. I think it was just sort of
So
described as,
you gotta understand what pretrial supervision monitoring is
Yeah.
in terms of corrections work.
Yeah.
Could be once a,
Could be a phone call.
could be a phone call once a month, could be a phone call once a week. It could be a check-in in terms of the PMP. If the person keeps violating those, it could then go actually into more one-on-one supervision on a regular basis. And it could also be electronic monitoring with the police.
But so this is not meaningfully distinguished from what's happening in PNP right now, and it's all just at the discretion of the commissioner.
It's different, pretrial supervision is different than what is normally monitored through PMP
Yeah.
for folks. And the testimony that the Commissioner of Corrections gave, this was asked, he indicated it would be kind of like pretrial supervision monitoring. So there are parameters around that we've put in the statute. That's very different than if someone is on probation for furlough or parole. Because pretrial, they're supervising based on the conditions that the court has set, but there's also conditions within DOC that has to be met as well. And some of those conditions also have to be met if they're supervising someone on furlough. Like if their bracelet doesn't work, they're not going to be penalized. But if they take the bracelet off, then that's a violation of DOC's condition. It's not a violation of the court's condition. So they would be answered to DOC, not the court on something like that. So there's a different layer there with the pretrial supervision. But the commissioner said they do it like they do pretrial supervision now. Think that they do, or I don't know.
Right.
Because pretrial supervision is not carried out throughout the whole state. Only where it's funded and only where they have the actual person in that PMP office. We only allow up to 5 people. They have 3 already. Pretrial supervision,
And so in the absence of that, what happens?
I don't know. I don't know, because we want to repeal pretrial supervision. We were gonna repeal it. So we allowed the money to be there, the 660,000 from a couple of fiscal year budgets ago. We allowed the money to stay to hire 5 folks, and it was for the accountability doc.
Hmm.
That's what it's for. We have 3 already. The other 2 where they were gonna extend the accountability doc. So it wasn't connected to this at all at the time. But now it is. We're gonna repeal it, and DOC didn't want us to repeal it. Well, now you see why. I think it's just,
Well,
I know.
interesting timing here because I've gotten to the point in the walkthrough of the bill
Yeah.
where it's really you guys and Katie. And she's actually interestingly, or she down the hall, is it upstairs? It's upstairs, I think. She's in house healthcare. Because we're switching places. She's doing her pieces in house healthcare. And I'm doing my pieces with you guys, and then we're gonna switch. She's gonna come down here and do her pieces with you guys, and I'm going up there. But one thing I'll note before we do make that switch, because these are her sections. And for the most part, House Judiciary stayed clear of these because they're assuming you guys are gonna look at that. One piece they did add is on page 19. And that's just because it was in the same request from the Center for Crime Victim Services. that I mentioned when we talked about the 2 pieces that we added already in response to their request about their opportunity to make statements at the hearings. They also wanted the rules, you have this existing piece that the rulemaking, they wanted to have some of their issues addressed in the victim notification procedures addressed in the rules. Which events would trigger victim notification at the forensic facility, how they would be provided with notice and that informed of their rights to receive notifications, that sort of thing. Again, sort of stuff that this committee is, I know, very familiar with. But just a note for you that that's where that came from.
Ask another rookie question. I've heard the term check back, or shouldn't we put a check back into the law or something like that? What does that mean? I have in my mind what it means, but I'd like to hear what your definition is.
What we were talking about, I believe, is having them give instead of the rulemaking. It was the October 1st, this once, we're saying, if they're going through, if we're gonna keep this language and the agency is doing rulemaking, they need to come before joint justice oversight at each monthly meeting to say where they are in the process, so we can keep their feet to the fire, but we know what's going on. That's what we were.
That's what check back means. As a-
Chicken, whatever.
As opposed to, we don't like what you're asking for, but we don't have a better solution. So we're gonna approve it, but in a year from now or whatever, we want to see a report that tells us that you were right in your recommendation, or, you know what I'm saying? I'm not stating it well.
You did.
We're gonna go along with your recommendation, administration. But we want to see you prove to us that it was the right decision in a year from now or something like that. Based
Before
on,
you can move forward in the next step.
yeah.
There's a legislative check-in. You can't go to the next step until there's a legislative action of some kind.
And is that the same as a check back, or is that a different word, or
That's how you use it. Check back is kind of, you can check in as you're doing something. It depends how the language is done.
so it's more of a generic term? Okay,
Yeah.
all right, I got it.
But some of that is in section 7, that interim reporting, this idea that they have to come back and report to you guys and the other committees that have been looking at this with their draft rules and project reports and that kind of stuff.
We're gonna be probably changing all of that.
I'm sure you will. Yeah, exactly. You can put as many requirements on that as you want. and-
Tell them not to do rulemaking, maybe come back with us with a plan in terms of how you anticipate carrying this out.
Sure, you could do it that way too. Absolutely.
Instead of, they're making rulemaking for something that hasn't even been established. Really?
It's really
I
ridiculous.
mean, you got the cart before the horse. Rulemaking carries out the intent of the law.
Right.
And rulemaking is how they will proceed. It's how they would carry out section 4, which is really the definition of forensic facility. We haven't really approved a forensic facility in a correctional facility at this point.
Right.
So they're gonna promulgate rules, and the rules have to come back to us.
Yes.
Session,
We haven't approved them.
we have to approve.
Well, you don't have.
Good point.
Go through rulemaking is very laborious.
Yeah, true.
So, for a feasibility plan, how are you gonna carry this out?
Right.
You're gonna do this, how are you gonna carry it out?
Yeah, they definitely go that route.
Anything else of Eric?
Thanks, Eric.
I bet. All right. Any other questions though? Oh, look at that.
Yeah.
Oh my God. That is like literally.
Pretty good.
We're gonna take a 10-minute.
We didn't even
Oh,
plan
no,
that.
you're too early.
Do you have a break, Peggy? No. Okay, we're gonna have a break.
Are they on a break up there?
Yeah.
Oh, there?
Well played, guys.
Put one eyes up.
It's,
Mhm.
at 10.